When the Cleveland Browns betrayed their hometown and announced a relocation to Baltimore, Maryland, the Ohio State legislature worked quickly to codify new regulations that would ensure it would never happen to another professional sports team in the state. Known as the Art Modell Law, it basically states that any franchise playing in a tax supported stadium and receiving some sort of financial assistance cannot leave without permission or the city being provided an opportunity to buy the team. While the law itself is seen as legally dubious in some quarters, it's not particularly onerous on team owners. If a city has skin in the game in the form of a tax supported stadium, then it certainly has a right to some sort of protection on its investment. With that in mind, can the Modell Law actually be used to stop a sports team from relocating, and is it something more states should look at implementing? To answer those questions, we need to head to Ohio, and absolutely not. We will not be doing that here. I will not stand for that. Jesus Christ. Why did the Drew Carey Show have so many different introductions? It was only on for like 7 years, and it had far too many. Shit. I do not think that show was particularly funny. I absolutely loathe the Mimi character, and I do not know anything about Cleveland rocking, but it is where we start this video and a law that came into life because of the Cleveland Browns in one of the NFL's darkest days. When the Browns announced they were forsaking decades of histories to go chase a new stadium elsewhere, it just sucked for everyone involved. It made little to no sense and left Cleveland high and dry. On June 20th, 1996, in the aftermath of that decision, the Ohio State legislature announced it had passed Section 9.67 of the Ohio Revised Code. Let's just go over it as it is. This is what the law states. No owner of a professional sports team that uses a tax-supported facility for most of its home games and receives financial assistance from the state or a political subdivision thereof shall cease playing most of its home games at the facility and begin playing most of its home games elsewhere unless either A, enters into an agreement with the political subdivision permitting the team to play most of its home games elsewhere, or B, gives the political subdivision in which the facility is located not less than 6 months advance notice of the owner's intention to cease playing most of its home games at the facility, and during the 6 months after such notice gives the political subdivision or any individual or group of individuals who reside in the area the opportunity to purchase the team. In other words, any team in the state of Ohio that plays in a stadium that has used public funds to be built and receives some sort of incentives or tax breaks or whatever the case may be from the state or city cannot simply up and move. Either they need permission from the state and city to do so, or they need to allow the city to find new owners for the team. As mentioned earlier, this was implemented by the state government in the aftermath of Modell moving the Browns to Baltimore in a fairly hastily arranged relocation that really did no one any favors. In fact, it was so bad that the NFL had to undo it by granting Cleveland an expansion team. A sports league admitting that one of its owners acted in an unbecoming fashion and then going a step further by correcting that error. What a novel concept. Oh, a simpler time, those 1990s. All of that being said, the Modell Law is vague and has never been truly challenged in the courts, although that almost happened in 2018 with the Columbus Crew. Late in 2017, then Crew owner Anthony Precourt announced that he would be relocating the site from Columbus to Austin, Texas. Apparently, though, before he came out and publicized the move, he did like zero legwork. For starters, Columbus soccer fans are not to be trifled with, and the team's owner, Precourt, should have known that from the start. It seemed like he basically assumed they would open the door for him on his way out of town and thank him for all of his support over the past few years. That, of course, did not happen. But before I get into the rest of this story, I just want to say what hurts me most about Precourt's actions in Columbus is that he changed the original Crew logo. That thing was awesome. The changed logo was the least of the concern for those Columbus Crew faithful, however, who found their anger being supported by both the city as well as the Ohio District Attorney's Office. The latter sued Crew ownership for running afoul of the Modell Law. Those running the MLS team did not believe the legislation applied to them when they announced their move to Texas. Eventually, things ended up in court, but we never really got a resolution on the legality of the Modell Law per se. That's because the court never actually ruled on the merits of the case or if the Modell Law applied to the Columbus Crew. What the law actually did was simply just hold things up entirely. In fact, the court went on to say that the 6-month notice period was paused during legal proceedings. As both sides were working through the lawsuit, it was never stated if that pause period had technically begun, given how the team announced its move. Things were shaping up to get messy, like really, really messy, facing an extended court battle that would not only delay the team's relocation to Austin, but that city's own attempts to build a new soccer-specific stadium. It forced everyone to sort of sit down and actually talk and work something out. That meant this ordeal never made it beyond the preliminary court proceedings. Eventually, they did just that. Precourt would sell the Columbus Crew to a local ownership group, that being one led by Jimmy Haslam, the Cleveland Browns owner. The MLS then turned around and granted him an expansion franchise in Austin, and Columbus went on to get a new stadium built for the Crew. Best of all, both Lower.com Field and Q2 Stadium are outstanding MLS facilities, certainly in the top half of the league. While we didn't figure out the validity of the Modell Law, certainly the MLS came out with a net positive in all of this. That entire saga probably highlights what best the Modell Law serves as: an obstacle, a roadblock for franchises who normally want relocations to be quick and easy processes because they can be very messy and very damaging to everyone involved. Would the Modell Law hold up under an actual judicial test? The general consensus that in the legal community is that it very much would not. It would need to make its way all the way up to the Supreme Court to eventually be decided, but most lawyers, most legal experts see a lot of potential issues that could arise should it be challenged in the courts. Ultimately, the Modell Law is likely to be deemed unconstitutional, which is obviously why it would need to make its way all the way up the court system. But to better understand just why that is, we need to explore Article 1, Section 8, Clause 3 of the good old United States Constitution. This clause states that only the federal government can regulate commerce between states. That is otherwise known as interstate commerce. Let's put a pin in that phrase though, because we will return to it in just a little bit. There is some precedent as the interstate commerce clause relates to sports team relocation. A Louisiana judge confirmed it to be applicable when the New Orleans Jazz moved to Utah. The relocation of a sports team was not a state matter, but one that was to be governed by federal laws. That then means the Modell Law is unconstitutional because it undercuts the federal laws on interstate commerce. Going back to the Columbus Crew for a second, they most likely would have emerged victorious in a legal battle against the state of Ohio and the city of Columbus as it related to that legislation. But the amount of time and resources required to defeat the Modell Law were deemed not to be worth the hassle. And again, just to clarify this point, that kind of is why the law exists. It isn't to prevent a sports team relocation. It is to simply make the process longer, to buy cities, to buy states more time in Ohio should a team want to lose. If it did not exist, there is no doubt the Crew would have moved to Austin, Texas. That potential lengthy legal battle, though, is what kept Precourt from simply packing up and leaving one day on a whim for Austin, like Modell had done with Baltimore decades previously. In that regard, the law works. It serves its purpose. It doesn't let franchises and team owners leave as quickly as possible without facing any sort of scrutiny. In Ohio, any potential relocation attempt is going to be messy simply because the Modell Law is there. However, should an NFL, NHL, NBA, MLS, or any other sports team wish to relocate and fight the Modell Law, they would eventually win. Now, the delays, the timelines, and all of that would pretty much ruin those attempts or potentially ruin those attempts, but we do kind of get the general consensus that the sports team would eventually win and the Modell Law would be defeated. That, though, brings us to Major League Baseball. Oh, Major League Baseball. This is the only sports league that claims not to engage in interstate commerce. That, by the way, is actually the crux, the center of the sports antitrust exemption. It allows it to be a monopoly. That antitrust exemption is really loved quite a bit in baseball by owners because it allows them to get away with all kinds of dodgy behavior. Everything from suppressing player salaries to engaging in monopolistic activities. Everything from service time to just how veterans have been squeezed out of the game. It all goes back to Major League Baseball's antitrust exemption and its clear statement that the sport does not engage in interstate commerce. Of course, that admittal means that no baseball team could successfully argue against the Modell Law because the Modell Law, if it was going to be defeated, would need to claim the league was engaged in interstate commerce. That means any Major League Baseball owner that wanted to potentially fight the Modell Law, hypothetically speaking, of course, could not do so successfully without also throwing the sport's antitrust exemption under the bus. Seriously, either you are engaged in interstate commerce or you're not. There's no middle ground here. You don't get to pick and choose. So if, again, hypothetically, a baseball team didn't like the Modell Law and it wanted to fight it to engage in a relocation, basically it means Major League Baseball would be forced to give up its antitrust exemption. All of this begs the question, why are more states not implementing their own version of the Modell Law? In particular, those states that do have a Major League Baseball team, the one league where the Modell Law would most likely hold up in a court of law. Some out there would say any state that imposes such a law would draw the wrath of its baseball team or any of its professional sports teams and that they would leave before it could be implemented. And I mean, maybe, but why would any other state want to do business with that sort of entity to begin with? One that didn't actually want to commit to its local market. Honestly, teams would, in theory, welcome this. They all say, we're committed local partners. We don't want to go anywhere. Now, they're moving because the state wants to implement its own version of the Modell Law. What they're really saying is the exact opposite of that. We're only here for the best deal possible, and if you do not give us the best deal, then we're going to up and move, and we want to have that flexibility. There are also other scenarios where it's just not going to make sense for a team to move. Is a team in a new stadium where the Modell Law gets implemented in going to leave that new stadium because they don't like the law? I doubt it. I mean, sure, anything's possible, but realistically speaking, franchises in newish stadiums aren't going to up and move because the state enacts the Modell Law. It is also extremely important to note that this law only applies to those team owners, those franchises that both play in a publicly financed facility in some form or the other, not 100% publicly financed, but if taxpayer dollars go to that stadium and then the team itself receives some sort of tax break. We don't actually know what that all entails based on just how the Modell Law is worded, but some sort of incentive, some sort of tax break, some sort of support from the local government or state government. If teams don't have both of those, then they don't have to worry about the law anyway. Those teams not using taxpayer funds or incentives or whatever the case may be are free to do whatever the hell they want to do. That is their right to do so. And that, I think, is totally fair. It also may encourage more privately financed stadiums to get built across America. If you don't want to be tied to a potential Modell Law, well then pay for it yourself. Asking for a commitment from an ownership group that accepts tax dollars and other incentives, it's not outlandish, it's not overly burdensome, it's perfectly reasonable. And again, teams are always free to build stadiums without public support. I am sure there are countless investment firms out there ready to provide team owners with high interest loans that have some terrible terms and that they can use those to build those stadiums they want. That brings me to the Oakland A's and California as a whole, a state that would have clearly benefited from passing its own version of the Modell Law years ago now. This isn't even a recent thing, this is something that could have been done ages ago by those in Sacramento. It would have made things far easier with the Kings and Raiders, as well as the Athletics currently, but efforts were never made by anyone in the state. No one bothered to look at this and go, this might be a good idea since we do have these publicly financed stadiums around. Either owners can do it themselves, like we saw with the Warriors in the Chase Center, or they can tap into public funds and be obligated, be committed to these regions via the potential Modell Law or whatever it would get called. To me, though, I think this is something every state should be looking at. There should be a desire for this type of legislation on the books, especially considering how MLB continues to threaten relocations left, right, and center. Better yet, how about some federal guidance here on teams that use public funds for stadiums? Again, the goal here isn't to create a burden for those owners, those franchises who pay for something themselves, but for those who don't pay for things themselves, for those who do want tax breaks and incentives and publicly funded stadiums, it would be great if there was something clear for everyone to follow so we don't get into these situations that are just nightmares for everyone involved, for cities, for teams, for fans. It's just shitty. Of course, that would require politicians on both sides of the aisle, regardless of where they sit on the political spectrum, to, turn their backs on huge billionaire donors and actually do something that's become increasingly rare in all of politics, that being focus on their constituents, the people that actually vote them into office. This may make it the biggest pipe dream of them all. At the end of the day, the Modell Law, at a state level, at a federal level, at any level, it just makes too much sense to not do, which of course means it'll never get done apart from Ohio, who did a good job. So yeah, the Modell Law can work. It's proven at the very least to be an obstacle in the way of team relocations. But yeah, those outside of Ohio probably don't get your hopes up, even though it can be an effective way to prevent team relocations. Thank you for watching this video. If you'd like to know more about the wild history of MLB or NHL relocations, we'll check out the videos on the right-hand side of your screen. Till next time, I am Cheyenne Hollis. This is The Touchback, and as we do say around here, hashtag take it out to the 25.